One of the most famous statues of all time is of David carved out of marble by Michelangelo. The question is, can this story teach us anything about the Matthew Hoover case? In fact, could it be a defense in the Matthew Hoover case? Stay tuned. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. All right, folks. Just as a reminder, Matthew Hoover and Chris Irvin are in prison now because they've been convicted of selling effectively or distributing an illegal unregistered machine gun consisting of what is known as an auto key card, which is essentially a thin piece of metal approximately the size of a credit card, maybe a little bit bigger, with some etchings on it, that this is somehow a machine gun. Now, this does seem to be a little odd. Nevertheless, here is where we are in the world. The question is, now that you've asked me to take a look at some of this case, which I had not done really beforehand, I have a couple additional observations. Specifically, I'm familiar with a story that I want to recount to you and then explain to you how it might actually help the defense in the Hoover case. There is a story that is not true, by the way. The story I'm about to tell has been told repeatedly, but it's actually not historically true. With that said, there's a lot of lessons to it. Specifically, one of the most famous statues of all time is the carving of a marble statue of David by Michelangelo, one of the greatest artists of all time. Now, this story, which is not true historically, but is often said, is, and it goes like this. The idea is, well, how did you, Michelangelo, actually carve this beautiful statue of David out of marble? And he's supposedly said, that was very easy. You see, I sculpted and cut away every single thing in that big block of marble that did not look like David. And boom, I had my statue. Well, of course, that story, which is not true, teaches us quite a bit of things, which is that all things that we use come from some sort of raw material. They come from a block of stone. They come from a block of marble. They come from metal, whatever it is. So it really does speak to a serious question involving this Matthew Hoover case, which is, at what point does raw materials or some item become something else? Or as a phenomenologist might say, for those philosophy experts out there, what is the essence of a machine gun or a machine gun part? Now, just as a reminder, under the relevant federal statute, Title 18 here, involving what is a machine gun, the relevant definition in the National Firearms Act states that a machine gun includes, quote, any part, singular, any part designed and intended solely and exclusively for use in converting a weapon into a machine gun. That's one way to do it. If you can find a single part, any part designed and intended solely and exclusively for use in converting a weapon into a machine gun, that is a machine gun. Here, however, it is pretty clear that is not what's applicable in the context of the Matthew Hoover case, because there's not a single part that is solely and exclusively used to convert a weapon into a machine gun, because obviously, at a minimum, these auto key card things that allegedly are a machine gun, they have to be broken up into multiple pieces, and all sorts of things have to happen to them, so they're not like a single sole part. And also, the solely and exclusively is not possibly true, because you could certainly use these auto key cards as artwork, as a graphic design, as a teaching tool, as an instruction manual, whatever. The point is that there's no way that they could be viewed as intended solely and exclusively as a tool for converting a weapon into a machine gun. So that cannot play a role in the Hoover case. So really the only way the government can win this, or won this case, was the second part of the definition of machine gun here, which is, quote, a combination of parts designed and intended for use in converting a weapon into a machine gun. Did you hear what I just said? A combination, which means more than one by definition, right? A combination of parts, plural, a combination of parts designed and intended for use in converting a weapon into a machine gun. Well, set aside the obvious problem with the word parts, which means more than one. It's what's technically known as a plural count noun, by the way. The word parts means more than one. So how does a single auto key card, which is a single piece of sheet metal, constitute more than one part? But they can't count? Nevertheless, you get my point. But let's go beyond this and go back to the Michelangelo story. What the government is basically saying is, well, the metal associated with the auto key card could be carved up and modified and manipulated in some way that creates a machine gun part that converts a semi-automatic rifle into a fully automatic rifle. That is their argument. But I want to step back for a second, and I want to try to find another set of case law that might be important, an important legal precedent. Specifically, I want to talk about Judge Reed O'Connor's decisions spanking the ATF in the last 6 months over their attempt to redefine ghost guns, which, as you know, are simply this 80% receiver rule issue, basically pointing out that what Judge O'Connor is essentially saying is, look, a piece of metal or some raw material is not a frame or receiver until it's a frame or receiver. Specifically, what Judge O'Connor said is, quote, Congress has not extended ATF's authority so far that the firearm part is designed to be or may one day become a frame or receiver. This does not change the fact that in the moment we're talking about, which is in this case the trial presumably of Matthew Hoover and Chris Irvin, at the moment we're talking about, it is not a combination of parts. It might, with manipulation by the ATF or someone else, become a combination of parts that could give rise to a machine gun. But at the moment of trial, when it's just sitting there, it seems to me it is a single piece of metal with some etchings on it. And that is not Mark Smith. That is the view, I think, by analogy, of Judge Reed O'Connor last September, spanking the ATF down there in Texas in the 80% receiver issue, also known as the ghost gun issue, because this, again, is what he said, that the fact that a part of a firearm is designed to be or might one day become a frame or receiver does not change the fact that at that moment in time, it is not a frame or receiver of a weapon. So too in the context of the Matthew Hoover case, the fact that that auto key card could one day become a combination of parts that give rise to a auto sear / lightning link that could convert a semi-automatic firearm into an automatic firearm, at the moment it counts, at the moment of trial, let's say, or at the moment of sale, whatever you want to say, it is not such a part or combination of parts. It's not there yet. No different than a raw material of a marble block that Michelangelo looked at before he started chipping away and sculpting the Statute of David. The Statute of David. Do you see what I'm saying? This is why the metaphor of Michelangelo being given a block of marble and the decision by Judge Reed O'Connor in Texas 6 months ago and the Hoover case all tie together. It just illustrates the point that just because a piece of metal could, in theory, could somehow down the road become a prohibited lightning link does not mean that it is an illegal combination of parts today before being manipulated by, let's say, the ATF or others. You have to actually cut out these parts. You got to remove the materials around them. You got to manipulate them. You got to play with them to actually make this an illegal lightning link / auto sear, I presume. Right? You have to do that. Again, it's the same idea as Michelangelo. You got to carve it all out before it becomes the Statue of David. Otherwise, it's just a block of metal. Or in this case, with Michelangelo, a block of marble. And I just want to make one final point, that even the ATF, in their regulations over the quote-unquote ghost guns or 80% rule, admitted that raw materials or things that could become a frame or receiver are not frame or receivers. This is not Mark Smith. This is not the Four Boxes Diner. This is the ATF, okay? Quote, the final rule makes clear that articles that have not yet reached a stage of manufacture where they are clearly identifiable as an unfinished component of a frame or receiver e.g. unformed blocks of metal, liquid polymers, or other raw materials, are not frames or receivers. Are not frames or receivers. So, Mark Smith, that's the ATF. Final regulations, 80% receiver rule, ghost gun issue. Okay, folks, I hope you learned something here today about Michelangelo, the Statute of David, and the Hoover case, and some of the language from Judge O'Connor's decision involving the ghost gun rules. I'll put links to some of the stuff down below in the description of this video. If you haven't subscribed to the 4 Boxes Diner, I hope you will do so, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.